shall be heard. God save the United States, the great state of Florida, honorable court.
You may be seated. Morning, ladies and gentlemen. Welcome to the First District Court of Appeal. I understand we have some visitors from FSU. We will take the cases in the order that they appear on the docket. The first case is Elizabeth and Robert Pohlman versus Panama City Athletic Club. Appellant, ready to proceed?
Yes, sir.
Go ahead.
May it please the court, Mr. Talbert, good morning. My name is Michael Rabin from the law firm of Rabin Mulligan PLLC here in Tallahassee. I represent the appellants in this matter, Robert and Elizabeth Pohlman. I'd like to reserve 5 minutes for my rebuttal time, please. As cases go, this is a fairly straightforward one in terms of the facts and the procedural history that gets us here. And I'd like to take a moment and go over the ones that I believe are salient and I believe may help us clarify some of the issues that occurred. My client, Betsy Pohlman, joined Panama City Athletic Club, which does business as Gold's Gym, so I might refer to that entity as Gold's Gym today. Upon joining the gym, she was asked and did sign a membership agreement. Thereafter joining the club, she hired a personal trainer, Appellee Christy McKinney, who was specifically hired to train her, to perform personal training services. During a personal training session with Ms. McKinney, my client Betsy Pohlman was severely injured. Believing that it was negligence on the part of both Appellee McKinney and Gold's Gym, my client brought suit. Sometime after doing so, the appellees raised the membership agreement, which did include an exculpatory clause that they argued successfully below waived liability in favor of their clients. My client's trial counsel argued below unsuccessfully that the language of the specific exculpatory clause was vague and ambiguous and thus unenforceable. Trial judge agreed with appellees and granted summary judgment in their favor, and this appeal followed. It's important to note.
So how do you distinguish this exculpatory language from Shaw?
Thank you, Judge, and that really gets us to the point here. Shaw versus Premier, which is, of course, the 2006 case originating from the first DCA, was the benchmark that the trial court used and based its summary judgment ruling exclusively on that Shaw opinion. And I appreciate that question because, again, that really gets us to where we are here. Shaw does contain similar language and actually some identical words that are contained in the exculpatory clause here. We have some sharp differences, though, in the way Shaw was drafted and the way the exculpatory clause that appellees drafted. Not only that, we have facts that distinguish how those clauses should be applied. And I'd like to start with the clause itself in Shaw. Frankly, it's a well-drafted, fairly easy, understandable clause. And I'd like to go ahead and acknowledge that if the Shaw language was present in the language of my client's membership agreement, then this case should have, it would have been right to grant summary judgment in appellee's favor. If you look at the language of Shaw, we have there waiving all use, Premier is not liable for any injuries or damage to any member or guest. That is the operative clause in Shaw, and again, that's a pretty decipherable and easy to understand clause. It's very broad. It clearly indicates that any injuries or any damage to any member of guests, Premier won't be liable for. If you look at the clause in our case, we start off with all use of the fitness facilities shall be undertaken by buyer at his or her sole risk. So from the outset, we have in Premier a understandably broad, well-drafted release. It says whatever injuries you sustain.
Yeah, but don't they get more specific in the next sentence?
They do, Judge. And are you referring to the Premier language, the Shaw?
Well, it is further agreed that the seller is not liable for any injuries or damage to the buyer or his guests, nor subject to any claim, demand, injury, damages whatsoever, including but not limited to those damages resulting from acts of active or passive negligence on the part of the seller, its successors or assigns, or its officers or agents.
Absolutely, Judge, and it does get more specific, and frankly, that's part of the issue that we believe confused our client, and frankly, it makes it invalid.
Counsel, but isn't that language virtually indistinguishable from the Premier language? If you look at the second sentence in this clause and the first sentence in Premier, it looks to me that those are using virtually identical language.
Judge, that's a fair question, and again, I believe the trial judge, he focused on the language that was identical. Specifically, we have a phrase, passive or active negligence, that shows up in both. But our position is we have, again, Premier says, whatever injuries you may sustain, we're not going to be liable for. In the clause at issue here, prepared by Gold's Gym, we start out with use of the fitness facility. So they have narrowed the scope of their protection. Furthermore,
can you explain how that's narrowing the scope of their protection?
Well, our argument, of course, Judge, is here we have an injury that occurred while under the supervision of a personal trainer. Our client was not using the facilities that caused her injury. She was not running on a treadmill. She didn't have a cable snap on her neck.
Was she in the gym?
Absolutely, Judge. No question about that.
Isn't that part of the facilities of the gym?
She was in the physical facility. There's no question about that. But the ambiguity, we would argue, arises when we all try to figure out, was she using the fitness facilities? And our allegations in the complaint were that it was the negligence of her personal trainer, an employee of a Gold's Gym, that directly and proximately led to those injuries. It was not the facilities themselves. It was not a hole in the roof. It was not, again, faulty equipment or a treadmill that stopped in the process of her running. It was an individual that she hired separate from her agreement with Gold's Gym. She paid Ms. McKinney directly. It was different, Judge. And so, absolutely, that's a fair question. But I would suggest that forcing us to decipher what using the fitness facilities means indicates.
So let me see if I understand you.
Yes, sir, Judge.
You're arguing that Gold's Gym, you know, whatever the company that owns the franchise,
Yes, sir.
Is liable for the negligence of the trainer. You're not arguing that that there's liability for the trainer's negligence, because that's not part of this case anymore.
Yes, sir.
Okay.
And again, to get back to Judge Rowe's question, I want to suggest that it's again forcing us to determine whether use of the fitness facilities encapsulates being trained by an individual who's an employee of Gold's Gym.
So that's like, we have the contract, I'm going to have my membership with the gym, and then there's a separate contract with the personal trainer?
Yes, sir, Judge. And I want to be careful and not go outside of the record. My understanding is this was disputed. It was a separate joining the gym.
The contract, right? I mean,
Sure, and it was separate. Yes, sir, Judge. And she negotiated that, the rate, the terms, the time she would work out with this person, totally separate from anything she did with Gold's Gym, and totally separate from any term that was contained in the membership agreement. And so, again,
But the trainer was an employee of Gold's Gym.
That was our allegation, Judge.
Okay.
Yes, sir.
But counsel, even if we were to agree with you with regard to the first sentence of the clause, that it in fact narrows the scope of liability, doesn't in fact the second sentence re-broaden it by saying it is further agreed that the seller should not be liable for any injuries or damage, and it discusses any claim without limitation? Doesn't that re-broaden the exculpatory clause at that point?
If it does, Your Honor, and again, I believe that's a fair question, but the answer is it's a confusing one. It further creates ambiguity when we're trying to figure out whether we start with a narrow clause, then it gets broadened. One case that we've cited, it is, beg the court's indulgence, Murphy versus Young Men's Christian is the Second District Court of Appeals 2008 opinion. And in that case, what we have is the YMCA, their exculpatory language says essentially the the buyer releases us and waives liability and understands that injuries can happen even when reasonable precautions are taken. And the court there said, well, wait a minute, you confused us when you added that language about reasonable precautions. Did you mean that you're only waiving liability when you took reasonable precautions or not? And there the court said, you've created an ambiguity by adding that language. And I was
that language, YMCA promised to take reasonable precautions, so that would seem to be warranting that we're going to try to be careful here. So you might have a claim if they didn't do that. That's why that's confusing. Why does this contract? Why is this the same thing? I'm not seeing it, and help me here.
Thank you, Judge. And I agree that it's not the same thing. I believe it's an analogous situation in that Judge Rowe's question was, well, we start with a narrow scope of waiver, and then it rebroadens. And my position is, well, that makes it inherently ambiguous. To force a lay reader, to understand and make that distinction that, okay, I'm going to waive liability if I'm hurt using the facility, so if a bar falls on my head or a cable, and then to go down and agree to waive based on a second clause that we might all agree does broaden it. Again, I want to be candid with the court and say if the Shaw versus Premier language is what was used in this case, we wouldn't have a case and should be out on summary judgment.
And the second sentence broadening it, could it be said that it broadens it to the guest of the buyer? In other words, guests are not mentioned in the first sentence. I mean, if we go back to fifth grade, the first sentence is your topic sentence that defines the paragraph. And so, if you use these facilities, we're not responsible if there is some kind of accident as a consequence of using these facilities. And the second sentence says, and this is to you and to your guest. So it broadens it, but it broadens it to the guest. Would be one argument, wouldn't it?
Yes, sir, in favor of the guest, and I would agree and believe that's a good point. I appreciate you bring that to my attention.
Well, and also to add to what Judge Hawks just pointed out, it also broadens it with respect to the agents of the gym. That if there's active or passive negligence on the part of the successors, assigns, officers, or agents, and arguably one could argue that a personal trainer employed by a gym or could be acting as an agent. So it does, again, broaden it as to the agency relationships, does it not?
Yes, it does, Judge. And on that point, though, I'd like to quickly, my time is running low on me.
You are in your rebuttal time, just so you're...
Oh, yes, sir. Thank you. The fact that, in this case, Gold's Gym chose language that is more foreign to a layperson. So we have, again, successors, assigns, officers, or agents. That language in Premier simply says it's officers, employees, or agents. So I agree, Judge, that it might be seen to broaden it because agents might be a broader term than what Premier used. But the question is whether that's more understandable to the reader. And our position, of course, is that very language, not simply using a well-known term like employee, creates an inherent ambiguity and makes this clause invalid. And with that, I'd like to reserve the remainder of my time. Thank you, Judge.
Good morning. My name is Rappel, Panama City Athletic Club, doing business as Gold's Gym, and Christy McKinney. I'm from the law firm of Bozeman, Jenkins, and Matthews in Pensacola, Florida. May it please the court and counsel. Your Honor, since opposing counsel has focused on the language of the two releases, I do want to return to that issue specifically and recall that opposing counsel said that if the language is virtually identical, then there is no case. I turn to the appellate brief submitted in the Premier Shaw case because the decision in Premier Shaw cites a portion of the release language. But if we look to the broader content of the release in Premier Shaw, what we find is they're so close. And there's attention focused on the first sentence of the liability waiver in this case that says...
But the facts of a previous case are really only the facts contained within the opinion, correct?
That is correct, Your Honor. But I do believe that to the extent that there's a reliance upon there's some suggestion that the releases are different. I think it's misguided not to understand the background of the release in that case, which began by saying that the buyer uses the facilities at their sole risk, just like this one does, and also uses the term successors, assigns, and agents. But if we just turn to the cited language and the cited language in the Premier Shaw decision and compare it to the cited language here, they are virtually indistinguishable. The first says that Premier shall not be liable for any injuries or damage to any member or guest, or be subject to any claim, demand, injury, damages whatsoever, including without limitation, those damages from acts of passive or active negligence on the part of Premier, its officers, employees, or agents. The release in our case says, it is further agreed that the seller shall not be liable for any injuries or damages to buyer or his guest, nor the property of any buyer or guest, nor be subject to any claim, injury, or damage whatsoever, including but not limited to those damages resulting from the acts of active or passive negligence on the part of the seller, its successors, assigns, its officers, or agents. There's no dispute that Christy McKinney was an agent, an employee of Panama City Athletic Club, Gold's Gym. There's no, the language of the releases is virtually identical. The release serves to well protect the interests of the appellees in this case. To the extent that there's any other issue, including the capacity of Christy McKinney, we respectfully suggest that that issue was not raised below.
So in this release, when it starts off with the facilities as its first sentence, that doesn't limit the release to facilities.
Your Honor, I suggest that it doesn't say that it does. It says simply it's
well, if there are questions about what the release does, then doesn't that mean it does not survive summary judgment? I mean, that it has to go to the jury?
Well, I believe Florida law says that the words of a contract, which, and release certainly being that, should be taken for their plain and ordinary meaning. And if this is a declaratory statement that simply says that the user is going to use the facilities at his or her sole risk. Now, that, we suggest, is not inconsistent with the next sentence in which you say the people who own it don't bear any risk from your use. They're released.
Counsel for appellant has suggested that the first sentence and the second sentence create an inherent conflict which are confusing to the purchaser or to the reader. Can you address that argument, please?
Well, the Florida law holds that that the terms of a contract should be read in concert in an attempt to give meaning to the contract. They're simply the normal interpretation of the words used do not create an inconsistency. It's only through a series, we suggest, of gymnastics, mental gymnastics, in this case a linguist I think was brought in, that we can jump to the conclusion that somehow there's an inconsistency where the first sentence says that the buyer, the user, is using the facilities at his own risk, and then the next sentence talks about something different. It talks about not only are you using the facilities, but any act on the part of an agent of the operator is not liable for. And any act on behalf of the employee of the operator is not liable for. And we don't believe those are inconsistent. We believe that our position is that those are commensurate statements which simply amplify on one another. One saying is a declarative statement is a declarative statement, not a release. It's simply a declarative statement. You're using these facilities at your own risk. The next statement is you affirmatively release, in this case, Panama City Athletic Club and its officers and agents, from any liability associated with their active or passive negligence, recognizing that those two things can be distinct. There could be liability arising out of the use of a health club that is not related to negligence. And certainly this second sentence is addressing the liability that may arise from active or passive negligence, which Florida courts have found compelling in the area of whether a release
What is active versus passive negligence? I mean, because I have this vision in my mind that an employee is there and the rule is that you're supposed to put your weights back up or something, and she trips over the weight because the employee didn't tell someone else to pick up their weights when they were supposed to or something. And that would seem to me, okay, that would be passive negligence on the part of the employee perhaps, or is that active negligence on the part of the employee?
I believe that would be a case of passive negligence, a failure to perform some act that may otherwise be expected.
So what would be active negligence?
Telling that, in the case of an instructor, I think that's instructing a client to perform an inherently dangerous activity. I want you to use this machine when you knew the machine was broken. I want you to
But that would be okay, so that would be active. Go ahead and get on the treadmill, knowing that the treadmill has been having problems and it stops, I guess, with the example that was used.
Yes, Your Honor.
So that would be active. Now, is there any difference by the virtue of the fact that these two entered into a contract? I will take affirmative obligation on to tell you how much weight to put on the bar, or how long to stay on the treadmill, or how to do deep knee, whatever. Does this contract somehow taken into this facilities contract? You know, the faulty equipment, the negligent management of the facility? Is one contract subsumed in the other?
I'm sorry, Your Honor. I'm not sure I understand that question. I apologize. I want to be responsive.
If I understand it correctly, Ms. Pohlman entered into an agreement, a contract, with a trainer that the facility provided, and that trainer enters into this agreement, whatever it is, but it's a contract. And she now is being actively, where she's being advised to do certain things. And part of your argument is that if that trainer puts her on the treadmill that the trainer knows is bad, that would be included in this waiver.
Your Honor, I understand the question, and I apologize for my earlier not being able to understand where you were going with that. We do not concede that there are two separate contracts. A health club offers many services. In this health club, there's tanning services, which the tanning services. There's dietary services. These services all fall on the menu of services offered by the client. The defendant, Applee McKinney in this case, is an officer of the corporation. There's not a separate services contract attached to this. It's a menu just as if one would walk into a spa to receive a facial or nail service. It's a menu that the client can choose from, which is done here. Now, I'm not sure this is the point of the Court's question, but the other issue I think that may have been raised was whether or not this release of negligence was sufficient to release a particular type of negligence. And I believe the cases that we've cited speak to the point that a general release for negligence doesn't have to get to the point where it releases. For instance, in the Gambino case, where the Middle District talked about the argument that, well, your release didn't talk about potentially slippery monkey bars. It just said you're going to release us from liability for playing on a playground. And in Florida, we believe that a release for active or passive negligence, it's not required to specifically identify every character or potential type of negligence that may be envisioned. So we do not concede that there was a separate contract for services. Speaking back to the Court's question, this is a case where the plaintiff appellant entered into a membership agreement, and upon entrance, upon paying a monthly fee, was entitled to use the facilities, and available to her were then other services commensurate with membership for additional fees, and these may include tanning bed, nutritional service, specialized fitness service, but all offered by Panama City Athletic Club and its employees, in this case, Christy McKinney.
Counsel has also suggested that some of the language in the agreement that differs from Shaw, such as the words successors or assigns, which weren't used in the Shaw exculpatory clause, render it inappropriate to dispose of this case on summary judgment because of an ambiguity. How can you address that?
Your Honor, we would suggest that Florida law, and I particularly point out to the term agent. Florida law consistently defines agent to include employee. In fact, the standard jury instructions in civil cases, the Supreme Court has pronounced that an agent is a person who is employed to act for another and whose actions are controlled by his or her employer or are subject to his employer's right of control. That's exactly what Christy McKinney is. If the argument is that they didn't use a magic word of employee, there is no Florida reported case that suggests that the choice of the word agent as opposed to employee invalidates a release. Well,
I think part of their argument was that the contract has to have terms that the ordinary consumer would understand and know what they mean. And I guess his argument is that, agent and assigns is not something that the normal consumer would know the definitions of those. They wouldn't know what the Florida statute definition of agent is.
Well, just as a general principle, Your Honor, okay. I would suggest that's an untenable position because as a matter of legal precedent, that would mean that every single contract that an individual signs, which contains words that have an ordinary and understandable meanings, such as this one does, would then be subject to reconsideration simply because the party would stand up and say, oh, I really didn't understand that. The record evidence in this case is that
No, I mean objectively understandable to the general consumer, not specifically understandable to these consumers.
Understood. Well, and I do believe that as the general consumer would be the person consuming this vast array of contractual documents from home mortgages to anything else, I do believe that's a legal precedent without support. The notion that, but in this particular case, which I do believe is relevant, the appellant in this case has testified, and it's a matter of record, that she's college educated and that she did understand the terms of the release. What her in the lower court, what was argued was that although she may have understood all the terms and all the words, when it was all combined together, she and no one, this linguist said, that no one could understand all these things put together. I haven't heard that argument here, and I think the appellant's proceeding on a somewhat different course today. But I think that's the response to that question, Your Honor. The central concern today for the court has been the comparison of the language. We do believe that they're virtually indistinguishable. To the extent there is any other argument raised in briefs, we do believe this case is one that speaks directly to preservation of issue for appeal. We have a luxury in this case, and that is that the record from the lower court is rather thin. There was a 13-page oral argument. There was no written response to summary judgment submitted by the appellant. And reading the 2 or 3 pages of argument by the plaintiff's counsel and appellant's counsel to the lower court, we find that there were really just the one argument that supported by the linguist. Any other argument, respectfully, has been waived, and that would go to the specificity of the type of negligence as raised in the reply brief, to which we directed a motion to strike. And unless the court has other questions, that concludes my remarks.
Thank you. Counsel?
I know I've cut into my time for rebuttal. I want to specifically respond to a couple of points Mr. Talbert just made. One, he claims that the clauses at issue in Shaw and in ours are, quote, virtually identical. Well, we have to start from how Florida law views exculpatory clause, and there's no dispute as to what the law is there. They're strongly disfavored. They're strictly construed against the drafter, which is Gold's Gym here. And they have to be clear and unequivocal as to what, in this case, the Pohlmans were giving up. I'd suggest that virtually simply doesn't cut it. If Gold's Gym wanted the same protection that Premier Health Club got, they should have had language not virtually similar or close, but identical to it, and not include language that makes it confusing. As a related point, we talk about whether agent means...
That's kind of a tough standard to meet, because there are different goods and services provided by different businesses that seek these exculpatory clauses. I would see a situation where, it might have to be different. You're asking for word-to-word fidelity to Shaw?
That's a fair point, Judge, and I'm not suggesting that. Certainly, though, we're in a context here that is somewhat of a subset of services, which are gyms. And personal training services are not a new thing. If it is such a broad service, as Mr. Talbert suggested, then make your exculpatory language read that way and say any services that you might obtain here are going to be covered in this clause, and you will not sue us. You cannot sue us if you're hurt using the array of menu items that we have at this gym. They simply didn't do it.
Well, that's not what Shaw said.
Absolutely not, Judge.
Okay.
And we are,
But Shaw did say, Premier shall not be liable for any injuries or any damage to any member or guest, was the opening sentence of the paragraph. And then it goes on. And this paragraph says that it is expressly agreed that the use of the fitness facilities shall be undertaken by the buyer at his or her own sole risk, correct? I mean,
yes, sir,
one
Judge.
starts off with facilities, the other says any injuries.
Well, if I can, we have Gold's Gym in a position they knew to add loss of property or damage to property. So they knew how to broaden it. They chose, for whatever reason, not to do that and left it narrow as to the use of the facilities. My time is up, and I appreciate this opportunity. Thank you.
Thank you, counsel.